So good afternoon, everyone, and welcome to today's Smart Talk on AI and the employee lifecycle, legal consideration from hiring to exit. I'm Gaurav Sawant, your host for the session. Usually, our Smart Talks feature a single expert speaker, but considering the depth and the importance of today's topic, we have something special. A distinguished panel of three legal experts from LawKNIT who will share their insights across recruitment, employee data, documentation, and AI policies. Our first speaker, Arnab Chaudhary, is a partner and co-founder at LawKNIT. He brings 15 years of experience advising corporates, banks, fintechs, and startups worldwide. He has been featured in the Forbes Power list of top lawyers and recognized among Asia's leading corporate and fintech legal practitioners. Next, we have Renu Sirothia, partner and founder at LawKNIT, with 12 plus years in policy, regulatory, and ESG domains. Renu has contributed to national initiatives like Digital India and Dot Bharat with METY. She is also an accredited mediator, certified CSR auditor, and lead privacy assessor. Completing our panel is Tanvi Muralidharan, partner and co-founder at LawKNIT with 10 plus years of experience. Tanvi has guided corporates, startups, and MNCs on compliance, employment, and data privacy. She is also a DSCI certified privacy lead assessor and an Asia Law notable practitioner for corporate and MA. With three accomplished speakers today, we will be covering AI in recruitment, then protecting employee data, essential lifecycle documentation, and AI-driven policies. Let's begin with the first focus area, the use of AI in recruitment and data protection. Over to you, Arnav.
Thanks, Gaurav. Welcome, everyone. Gaurav has already given a nice introduction to all of us. Uh, Let me share my screen.
Yes,
Yeah, I hope the presentation is visible.
yes, it is visible.
Yeah, so as Gaurav has introduced the topic, just to bring the legal part to it. So as you all are from HR fraternity and you have been using AI into various aspects of HR. The reason for today touching this topic from a legal perspective was to also understand the legal implications and legal requirements involved into using HR into using AI into various HR functionalities. Now, apart from me, there are two other presenters, Renu and Tanvi. Both of them brings a unique capability. Tanvi deals with a lot of general corporate and HR related, labor law related issues. So she will take us through the nitty-gritty of clauses and agreements and the changes which is required in order to upcoming AI related activities in an organization. And Renu also assists us, or Renu heads our policy practice. She is more into upcoming future policies which are required for an organization while implementing HR into the domain, implementing AI into the HR domain. Now, just to take you through what we are going to cover today in our presentation. So we are going to take 7 topics overall, divided into various subtopics. The first topic is with regard to legal risk, biases, regulatory concerns surrounding AI. Then we will take us through the must-have legal documents in India. Vital legal clauses, how data protections and all those things will work in AI domain and KMP related aspects. Then Renu will take us through the different stages at which AI is being used and what all are the policies and organizational measures which are being implemented in India as well as globally. Now, before to start with the presentation on legal aspect, just wanted to showcase what has happened across the globe or especially in US with regard to the use of AI in HR segment. So you must have heard about this Workday matter where Derek Mobley was applying for various positions in an organization which were using Workday AI tool as an AI assistance hiring tool. Okay. And what Derek Mobley is, he's a person of 40 plus years of age, African American, disabled. He applied for almost more than 80 job profile and he got rejected. Okay. Somehow he tried again with a little bit different or a better profile, and he started getting selected in some of the interviews. Then he realized that there is something which is happening with regard to the selection process and the way AI is screening the CVs or resumes of applicant. Okay, and on that basis, and as you know, that US is a very much of a market which is very litigation heavy. He filed a suit against Workday, complaining that it is biased towards certain age, race, disability, and all those things. Given that the US court has admitted and allowed for a class litigations across it. Okay. Now, similarly, with Amazon was using a AI tool somewhere around in 2018, and they discovered that there was a gender bias going in. The screening of CVs on the basis of male, female, transgender was being done with some kind of a bias. Now, what are all these things comes down to? Even though the AI saves time and cost, but if these things comes out, it brings lawsuit, it brings reputational damage, and of course the regulatory risk as well. Okay. So that's the context of today's presentation, that when we are using a AI and when we are implementing the AI, how the Indian laws, because what we have seen right now is a US or a global scenario, but what is going to happen in India? Are there laws which is covering such scenarios in India? Now, if I take you to the next slide, now if I cover these basic laws which are applicable, which will also be applicable for use of AI into HR related activity. One and the foremost is the Data Protection Act, okay, the DPDP Act, where the candidate's consent, purpose. So the two segment when it comes to DPDP Act and in case of a recruitment process. One, when you are recruiting someone, at that point of time, the person is not an employee; he or she is a potential candidate. Okay. Once the person is selected and gone into employment, then the person becomes employee. Now, the data privacy rules applies differently for a candidate whom you are screening for employment and for your employees. Okay, because there are certain exceptions given under DPDP Act. Okay. But overall, what it requires, a candidate access to the personal data which is being used by the organization, and he should also have a right of any other data principal with regard to access, correction, erasure of his personal data in an organization. Now, what is important when it comes to a potential candidate? Okay, so someone who is not an employee but has sent the resume, and we are looking into the resume of a person, and the resume has certain sensitive details, certain other personal details, photographs, phone numbers, lot many other things. Okay, how to handle all those things? So, consent is the way what DPTP Act says, that it should be consented, that you can use it for a screening purpose. If some AI tool is using those applications and all those things, then proper consent has been taken for applicability of that AI tool over those personal information of a candidate as well. Okay. Now, the second important aspect where the last two matters which we saw of Workday and Amazon, the bias risk. Obviously, the AI mirrors human bias of lot many other things. So we don't know when it is getting coded, how the AI has learned things. Okay, so it's very important for us to have a oversight, human oversight over the final decisions. And second, when a person is using a AI, or when a candidate is aware that his screening process is going through the AI systems and all, it's always advisable to keep a disclaimer language as well, which also shows or tells the user, the candidate, that how the AI works in a broader way, and what all are the risks or chances of errors are there in this AI. Okay, so it's always good to have a aware decision rather than being unaware about the screening being done by a AI or human, and how all things are work. Now, the third part, anti-discrimination. So in a non-AI world, India do not have a very, I will say, specific anti-discrimination laws, but there are various laws for certain categories of people protecting their rights and protecting them against any kind of a discrimination. Like there are laws which protects on equal remuneration. There are laws which protects women under maternity benefits. Then there are transgender protection. There's a protection for disabled people, and then there are protection for HIV related disease and other diseases. So technically, even though India do not have a very, I will say, a uniform singular anti-discrimination law, but the laws against discrimination has been scattered and has been applied for a specific segment of people. Okay. Now, all these laws, whether it's data protection, whether it's bias risk, whether it's anti-discrimination, all these applies today in a non-AI function, and the same will apply for any function which is being done by AI. So, from a legal perspective, there is no distinction whether you have done the process through human intervention or you have done it through AI, but the principles of anti-discrimination, principle of protecting the personal data, and all those things applies as it. Now, when it comes to judicial uh, policy safeguards, means how the courts are going to look at it. Courts protect any kind of court is against any kind of a workplace bias. It protects the employees from biases. Okay. Now, if I will say a workday kind of a matter or a Amazon kind of a matter would have happened in India, how court would have looked? Maybe it would have taken some more time or some more evidences to understand it better, but the legal principle against the bias would have been remain the same. So I don't see that the 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 judicial interpretation of the matter would have been very different from what we have seen in Workday or Amazon case in US. Okay. But yeah, the procedural lapses, the procedural delays on all those things, I'm not commenting on that. But from a legal principle perspective, our courts, the Indian courts would have also looked in a similar way because the employers are required to embed the principle of fairness in their policies and handbooks. Okay, and all the laws which I said which protects maternity women with maternity benefits, transgenders people and disabled people, all those things are there to protect the specific interest of employees and to protect them against the discrimination. So given all these scenario, our understanding is that if an organization is using a AI tool for various HR function, what we saw previously would have been taken in Indian scenario as well. Now, some good things about AI. So, in case of Unilever, it's a case study which shows that almost 250,000 applications were done for 800 roles, which generally takes around 6 months time to do the recruitment process. They adopted a AI called HireView, which has now cut down the timeline drastically. 80% of the candidate pool filtered efficiently, 50,000 plus hours of interviews were saved. Annual 1 million cost has been saved. So there are lot many benefits and there are lot many yeah, success stories are also there. Some of the studies also show that 60% of HR activity today, they're using uh, 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 one at least one AI tool for some or the other aspect of HR activity. And it seems like by 2030, almost 80% of the company will be using AI in their HR functionality. So, given this vast adoption of artificial intelligence into HR, which is very much a litigating point as well, because it has so many laws involved from a labor code perspective, as well as from a data protection perspective, from social benefit protection perspective. It's very important that the implementation of AI into various functionalities should also be evaluated because the risk will not mitigate by shifting human to AI. The risk will always remain with the HR team of the organization, and the organization will always be responsible, even though they are using a AI, whether developed by them or developed by third party. So, in order to mitigate these risks and to understand where the rights of the employee and where the rights of the organization lies, It's very important to have our documentation, our understanding about applicability of law on these AI tools and AI aspects, in hand. So now the next part, which I will like my colleague Tanvi to take us through, is actually about how we should now start looking at regular documentation. First, which all are very important documentation from a HR perspective and employee perspective, and what will be the the consequence of what should be the updation of or upgrade of these documentation from a AI usage perspective. So I hand it over to my colleague Tanvi from this slide onward. Thanks.
Hi. So I'll just take you through. First of all, I'll just tell you, I mean, I'm pretty sure you're aware of all the documents that you require from an HR perspective. But I'll nonetheless take you through why these documents are required and, what are the pitfalls and all of that. And also add on to that, wherever AI is something that, you need to sort of cater to in these documents too. So that's how I'll structure this entire thing. So first of all, offer letter or appointment letter. I mean, this is usually sent as soon as you offer a person like an opportunity in your organization. Usually with the very few things would be mentioned in this document. One would be what is the role, what is the designation, the potential salary that you're providing the person, what is the reporting structure. Typically, we also mentioned that, the confidential nature of that document, because of course, you don't want that person to carry that particular document and then, negotiate the salary with another person and all of that. So when there is a confidentiality provision that sort of stops that person from doing that. So all of those things are what is generally mentioned in this document. So from what Arnav was also describing, another thing that is also good to have in this document is like, at any point of time, if there is any sort of of course, there'd be personal information that is collected, processed, and all of those things. So it is always better to have that also identified in the document, saying that, you consent to the processing and all of those things, so that when they approve, then all of these things are kosher. And also, if there is any sort of an AI tool that you're using, then some sort of a disclaimers in relation to that also can be added. But if at the offer letter stage, if there is nothing, then you don't really need to do that. But we have seen that a lot of companies do use, let's say, like an AI for background verification, for example. So you have circulated the offer letter and you say, we use this particular tool for which we are going to process your information in this way. And, and this is how we are going to provide the background verification report. But having said that, even if you use a background verification tool or any such other tool, it is always better to have certain sort of a backup or a review mechanism from your end, from a personal end at the company side, to ensure that everything is proper with respect to that report. But in the documentation, of course, you can handle the acceptance of it, the consent of it within the offer letter. So then, of course, after that, and another thing, another clause, this sort of recently came into light also, and then we always add this particular clause, that is the non-disparagement clause. So now everybody is very active on social media, very active on, they are obviously aware of their rights too. So, like employees like generally people tend to sort of uh, write things on social media, on their social media profile, whether it be LinkedIn, whether it be Instagram, wherever it is, they sort of air out their grievances through these channels. Uh, so I say this from both the sides. From a company's perspective, so almost all, at least the ones that we draft at least, would always have this clause called non-disparagement clause. That means you are not allowed to say what your grievances are with the company, or like in a very bad, disparaging, in a defamatory matter, uh, out in the social media, out in any place in public, in fact. So So that is one clause that we add even in the offer letter stage and also in the employment agreement stage, so that the employees are refraining themselves from doing this. But that doesn't really mean that they don't have options or avenues. There are of course codes or arbitration processes where you can actually speak about these things. But mentioning that in a public this thing, especially when they like add screenshots of the communications and all of those things, not just like, breaches non-disparagement, that might also breach confidentiality, that might also breach, let's say, data, personal information of another person and all of that. And we have seen that a lot of companies also taking action in this regard. While this has nothing to do with AI, but this has been a hot topic because of recent notes that people have put online. So the next document that is relevant is, of course, the employment agreement. I'm not going too detailed into that. Of course, you will have your employment agreement, which is catered to different cadre of people. So for all employees, there will be a pretty standard employment contract, which is standard clauses of what their remuneration is, what their behavior should be, what is their code of conduct, what is the definition of cause in case of a termination, and that confidentiality, notice period, all of those things will be covered. All of those things will be covered, and of course, if the kind of employees that is joining is pretty critical, then you will also have non-compete, non-solicitation, and IP relating to IP, what IP they want to. If they're creating any IP, then that should belong to the company and all of those things. So these are the pretty standard agreement terms that will be there. From an AI perspective, again, what you might need to add either here or like I'll talk about the code of conduct next. So in the code of conduct also that what will happen is that you need to have like disclaimers, and basically it's not even disclaimers. You need to first of all sensitize your employees that you are using AI. So of course, most company is encouraged to use tools that will increase their productivity, and AI is one such tool. So you definitely need to ensure that your employees are also aware of the tools that you're using. The primary reason why we say that is because um, these AI tools usually access information of your employees to provide the required services, provide the required results. So that will include personal information. In almost all cases, it will definitely include employee personal information, their conversations, it could be their behavioral patterns, how they all of those things. So that is how you sort of create a roadmap as to what they are dealing with. Even their leave patterns, everything will be sort of tracked. So all of those can be considered as personal information because that is identifiable of that person. So as a result, when you're using these AI tools, sensitize the employees, because while data privacy laws allows you to access such information of an employee uh, for employment purpose, using AI might not be considered very critical to providing employment to a person. As a result, it's always better to have the clauses in your draft saying that this is how you're using their information. And the reason why you're using this information is to provide them with better service, easier, this thing, reduce the lead time and all of those things. And then have that within the documentation and the code of conduct. So that's what I was talking about. The next one, the code of conduct. So here you definitely need to mention, if not in the agreement, at least in the employee handbook, you need to ensure that these things are mentioned. And also, it would be always better to have in these documents when you're using the AI. First of all, what you're using it for, what type of AI you are using, and how that will benefit the employees and the whole grand scheme of the company. And how you're also trying to mitigate, because we all know that AI is sort of riddled with a little bit of biases, which creeps in from the data that is fed into the AI, right? There are tools to mitigate that. Most people are using those tools too. But even then, from a company's perspective, from an HR perspective, it is always better that you mention a process, like say that while you can rely on the AI, while you can rely on the data that is provided by AI, you're also advised to actually look at the agreements and all of those. Okay. And then another thing that you as an entity should also make sure is that access controls, obviously, because not everybody needs to access all the information. For example, you should ensure that if you're querying an AI, it shouldn't show other people's salary details. So you need to ensure that those access controls are maintained within the organization and within while you are using technology like that. So that's what we were talking about in relation to Chinese wall. Ensure that people are privy to information only those information that they actually need to access and nothing more than that. And all of these things has to be mentioned in a policy. Internal policies should be maintained so that everybody is clear as to how this needs to be used, what are the kind of AI that is being used, and all of that. Um, then lastly, stock option. Here, it's not really relevant from an AI perspective, but of course, we do have ESOP agreements and stock options for senior employees or for mostly for retention of employees. And this will be a separate policy and a whole set of documentation will sort of follow this. And in that case, all of their code of how they need to behave, all of those things also sort of can be one of the conditions to ensure that they get the stock options vested. Lastly, I think what is critical, I'll just start with the confidentiality first. While most of the employees will have confidentiality provisions within their document, we also see that in certain cases, it is also better to have confidentiality and NDA documents which is separate, which is be project driven, because if their role is a little more specific, or they are employed in some project with some client specific to the client, and that client has made the company sign certain NDAs and confidential agreements, then in that case, it should also flow down to your employees so that they also are bound by the same NDA and confidentiality. But your typical clauses can be mentioned in the employment agreement, and or if you want in the code of conduct also, that's also fine. But other than that, if there are specific ones, it's always better to enter into that separately. Lastly, with respect to exit and this thing, exit. Sorry, I think. Lastly, with respect to exit documentation, this is also one of the places where a lot of people use AI to figure out what is the general feedback that employees have given. And, so all of these things, first of all, will be documented that, you're collecting information as to exit and, how that works out and what is in the exit interview, what the person has said. All of those things sort of just get captured within the AI. And then that gets used to generate as to what is the reason for attrition, right? So again, in these cases, also ensure that these consents are taken when those things are recorded, and how it is recorded. All of those things also matter. And of course, your general exit documentation, of course, includes your the full and final letter. And even in the full and final letter, make sure you have clauses with respect to non-disparagement, confidentiality, to reinforce that when they go out, also they are aware that these kind of terms still continue. Just because they have stopped working in the organization doesn't mean that their confidentiality comes to an end, their rights to not disparage or defame the company comes to an end, all of those things. So it is always better to have those things added. And just one more point here, while it is not relating to AI, we all know that people in an organization do leave and join competitors, and that might be not 100% in line with what the agreement suggests. Employment agreement usually says just that you should not join a competitor and all of that. But there is in such cases we need to see where they have joined, what is their role, what is the level that the position that person occupied, and all of those things. But of course, that is something that the other person can disclose, and then some sort of this thing will have to be reached at that stage. So these are majorly what will be there in the exit and full and final settlement. But just having said that, there is one thing. They should also add a clause. You should also add a clause in the exit documentation, which talks about non-solicitation too. to ensure that, the person leaving doesn't poach the clients or the employees at a later stage, and that can be easily documented too. So AI will help you that in that too. When a person is leaving, it charts out where they're leaving to, what is the reason why they're leaving, and all of those. So that will sort of help you chart out the non-solicitation obligations too. Um, I think the next one is like, I think most of these clauses I've already taken up. One major, while I've seen non-compete, non-solicitation, IP-related clauses, which is pretty standard in all documentation, we seldom see employers putting in data privacy and data protection clauses, uh, especially with respect to consent. And while in employment, maybe you are protected under law when there is an employment scenario, you're protected under law from collecting information and processing information for that particular scenario. Uh, Again, I'm just reiterating this point. When you're using AI tools, that might not be considered, certain things at least might not be considered as within the realm of employment requirement. It could be because we don't have any case studies as of now. So in that case, it is always better to take specific consent at this stage. And also, as I said, if you're using tools for background verification or otherwise also, it is always better to take consent even before the employee joins you, because you will be collecting the information, processing it for various reasons. You will be passing it on between your within your organization and external too, because if you're passing it on to an background verification agency and all of those, and of course if you're passing it on an AI tool that to you does background verification, then also you need a consent taken before handling all of those sensitive information. So you need to ensure that that sort of gets catered to at every stage, before the person joins the organization, and of course after, through the employment agreement or code of conduct also. Um, so I'll just quickly take you through DPDP requirements. I mean, I've spoken quite a bit on this, but so right now there is the DPDP Act that is there, that is so effective within India, so which requires that you do something called privacy by design, essentially. That means your entire organization should be catered around privacy, around ensuring that person of information of a person doesn't breach, I mean, your usage of it doesn't breach this. So that mostly means that, you should only collect information that you require, and only use that for reasons, for the purpose that you've collected it for. Um, and if there are the special protections should be created around collection of information, storage of information, and transmission of information. That means there shouldn't be any breach with respect to personal information. And again, it's only personal information that this deals with, not confidential information. So the law doesn't protect confidential information, so that you will have to separately protect using your contract. This is only for personal information. That means something that can identify me, my email ID, my phone numbers, my address, my name, all of those are things that identify me. That is the only thing that is covered under this. Um, and of course, there is also certain rights that is given to a person. So this right will also belong to your employee. So the employee can at any point of time ask you uh, how my data is processed, where is my data, who all have you transferred my data to, all of those things. And in case of a breach also, there are certain reporting requirements and all of those. So all in all, there is a whole lot of things to be done with respect to personal information, and almost all the information that you collect regarding an employee would be personal information. So this will like squarely apply to all organizations. Um, just very quickly, KMPs are basically key managerial person. KMP is under Companies Act as a whole other connotation. There is filings required and all of that, but that is might not be how you understand it. It would be anybody that is critical to your organization, which could be a CTO, CEO, CFOs, or whoever that is managing head, whoever that is actually. HR head, whoever is a critical employee would be considered as a KMP. So it is always better to identify these people, and from an AI perspective also, to identify who they are, so to ensure that retention is high and all of those things. And then, of course, another thing that is very critical in with respect to KMP is that you might have a more stringent contract with respect to compensation, with respect to confidentiality, IPR, non-compete, non-solicitation, and all of those things. You might have to have a separate contract altogether, which is specifically catered to them, which might not be the case for your other employees. With that, I'll just hand over the slides to Renu.
Thanks, Tanvi. Uh, yeah, so it's
Thank
pretty important. Yeah,
yeah,
Renu,
thank
you
you,
can take
Tanvi.
it over.
Okay, so as we all know that there are basic aspects of governance which cover legal aspects, but there are also policy dimensions related to deployment of AI in any organization. So we all know broadly how there is certain overlap when it comes to law and policy aspects. But when we talk about policy aspects, we are not only talking about internal policies, there are some macro policies also which are applicable on, say, state level, country level, some reporting requirements, etc. So few of those dimensions I would be discussing. And if anyone has any queries at end of the sessions, they may be asking. So a very pertinent aspect is contribution of AI at different life cycle stages of any employment life cycle. So we know that AI deployment or use starts even before the recruitment, means even at the application stage when CVs are submitted. So organization has to be transparent about when they are calling for resumes that they are using certain algorithm for screening, etc. So at recruitment and onboarding level, there is a screening and skill matching, etc. When volume is high, it is done through use of AI. Then there is chatbot for induction, etc. So at onboarding stage, it is there. So at time of induction, also some trainings, etc. They are AI based. Then performance assessment, whenever it is done, a lot of things are automated, and key performance indicators evaluation also, specifically when organizations are huge and headcount is big, that kinds of AI tools are required. Then when we talk about performance improvement process, at that time also, whether it is at time of appraisal or it's at time of exit interviews, in all those cases data driven skill gap detection is done. And sometimes there are tailored trainings once we know what indicators are improving the performance, so it is highly useful. So whenever at these stages AI is used, some policy dimensions have to be kept in mind, which I would be discussing subsequently. Just quickly going through where all it is deployed. This is very broad aspect. Then from organization to organization, it differs. Uh, Nowadays, even for employee engagement, lot of analysis work is required, and sentiment analysis is done. AI enabled feedback is taken. 360-degree feedback also, it requires AI tools, etc. One very important aspect here on slide, I have not mentioned, but for retention also patterns are studied through AI. However, at those stages, as Tanvi mentioned, disclosures are important wherever AI is being used. So the people who are subject to it, they should be aware of that this is subsequent use. And obviously at exit and on offboarding stage also, for attrition prevention, for predicting the patterns of attrition, for developing the insights, who are exiting, why are they exiting, or who are the unproductive lot, who are retrenched. For all those things, AI analysis is done. Tools are also required for seamless transition, for whether that transition is at time of exit or at time of change management. So here I'm not going into detail, but even in cases when there is devolvement, if there is merger or management change, in all those the situations also some analysis through AI tools is done, so that it is known that whether employees are working properly under new management or during the change also. Now I would be going to the next slide, and we would be discussing other aspects. Just give me a Okay. So before we go ahead, it is important to reiterate the policy aspect, which are also covered under the legal aspects as discussed by Arunabh and Tanvi. There are various challenges which pertain to privacy, bias and transparency. So we all know that whenever AI is, whether when it is procured, when it is deployed, when it is utilized, even when it is improved, data privacy has to be maintained with utmost compliance level, and because there are various risks involved, and there may be unauthorized access, there may be misuse, or sensitive information may get leaked. So it is very important that organization takes care that privacy is one by design. Second, that privacy compliances are done. There are periodic audits and checklists are followed, and not only at the legal team level. Every team should ensure that privacy is there, and it goes hand in hand with security. It must be sensitized to every team that their systems must be robust enough. They may not be sharing their login data, etc., everywhere. Sometimes organizations think that these are obvious things and need not be told, but periodic trainings are very important to sensitize the people who are using the AI or feeding the data into AI, particularly for feeding daily timesheets, etc., for giving reporting, etc. Where all the organization, whether service based or product based, they require feeding the data. At that time, privacy is required. Another thing is if data is shared to any other party. So we already covered that in legal aspect. It's important that it must be on the basis of only as much required. Another thing is wherever possible, anonymization should be done or encryption should be done. So that is another important thing. So one is aspect of using AI with general methods. Other is technology is required. So every time whenever AI is deployed, uh, for challenges, not only data privacy challenges, there should be corresponding budget also. Now, coming to another aspect, bias in decision making. We know that when algorithms are used, there may be some inherent design flaws which may be creating bias. Another is there may be some unintentional discrimination which may be happening. So, not only there should be the mechanism to test the AI before it is deployed, there must also be adequate mechanism of feedback at every stage. And if some report is there that there is some bias occurring, there should be redressal. So, otherwise, if that is not that kind of mechanism is not there, organizations may get into legal soup. So it is good that disclaimers are given and there is adequate scope of getting the feedback and taking action on that. Another thing is transparency. So there are two words which we are often hearing, that one is transparency, another is explainability. So at the technology level itself, there must be adequate explainability that how AI is coming up with certain decision or how it is segregating certain data. Another thing is at organizational level, there must be adequate transparency to the stakeholders. In this case, as we are talking about HR, to the man to the team which are providing, say, people. So to our not only to the employees there should be transparency, but also transparency to the organization which are providing people for hiring. So for example, if there is some recruitment consultant or consultant who's doing background screening, or there is a secondment, etc., in those cases also it is important that uh, we know that what indirect AI is used. So every disclosure has to be there, and not only to the employees but even to the higher management, because ultimately in India as of now there is no such specific reporting requirement, but companies have to maintain their AI use, and in coming time there may be scenario when reporting is to be done to a specific uh, regulator. So in those cases, it would be good to maintain the transparency log of internal AI, as well as if any partner institutions are using certain AI. So at least some broad level information should be there so that it can be subsequently transparently disclosed. Now I would be moving to and other dimensions and to other slide. Uh, Again, as I said, could be potential policy measures and mechanisms, but as of now, there are broad principles which are observed across the countries, across the sectors, not only for data intensive sectors, generally also they are used. This is irrespective of the size of the organization. So first, transparency, which I already discussed, that there must be clear communication, and for that AI, whenever HR teams are deploying AI and applying AI, so it has to be very transparent, and they should maintain inadequate information about it. Another thing is continuous monitoring is required. Periodically review and update of AI must be there, whether the model is working properly, whether compliances are done, if there is fairness, if there is any feedback. And also it is important to note that sometimes organization acquire some AI, but after a while they may realize that it is not working for their system. So periodic review also helps to assess the relevance, because then they can either improve it or replace it with some other suit, depending on the function. Now, one important thing is there. Sometimes for each function there are different suits of AI taken, and sometimes there would be some macro suit available, which would be helping for all the functions, and it also helps in interoperability, and it saves lot of budget in data. So in that case, also monitoring is very important thing. Now, coming to the fairness and non-discrimination part, one, as I already discussed, that AI, whichever is at procurement level itself, it must be seen that it is properly designed. It must be tested. So obviously, organization who is selling the product, AI product, they would be doing their testing. But while procuring, each organization should see that it is properly working, and they must also regularly conduct uh, bias audits. Okay, so that those audits are done by specialists, and there are some standards also. ISO standard is there. IEEE also has some standards for that, which helps in they have checklists, and against that it is audited. So feedback of all the people, all the stakeholders, of the employer, of the employees, of the tech team, etc., are taken. So uh, even while performance reviews are done, or recruitment, promotions, any of the function when it is conducted, it must be seen that how AI is applied, how it is working, and whether it is fair in its approach. That must be ensured at all the times. Fairness is a very important benchmark. Uh, Another important part is, which is already we discussed in detail, that data privacy and security laws like GDPR and like DPDP Act, they must be followed, and it's very important that all the information which is collected, it is consent based. So every time there must be prompt which says that certain data is collected, and it would be used for uh, XYZ use, and data use must be restricted. Okay, so if for X purpose, say for the purpose of performance analysis, certain data is obtained, it cannot be used for other function, and if it is, that must be adequately disclosed to the subjects, in this case the employees. Another important thing is, at all the time, whether AI is very robust, also human oversight is very important, and this parameter is considered not only in India, it is considered across the countries, that AI is robust and it is accountable. However, periodically human intervention is there in form of auditors and experts who see that the AI is doing proper performance. So ultimately, policy broad level concept would be, AI is not a person in a real sense, it is virtual person, but ultimately liability is with the organization which is using the AI. So it is good for the organization also that they keep the human intervention, because if we know that automatically AI is learning, right? So it is ultimately machine learning and deep learning, and if they start using or misusing certain information, that must be periodically kept into control and check. So it's not like 100% viable, but best practice is that. Now I would be discussing some of the mistakes which organizations do. Okay, so one very common mistake which organizations do is that while covering notifications or while taking the consent, they do not cover all uses of employee data. So they would just say that we are collecting this employee data for, say, uh, appraisal purpose or for retention analysis. So it shouldn't be like that. Disclaimers must be comprehensive enough. Notifications must be not only at the right time and frequent, they must be comprehensive, and it must not be created in vague language. For that, experts are required, whether it is AI auditors or privacy assessors or lawyers, but that proper language is required, and each organization must be mindful of that. Now coming to another challenge, that not ensuring routine checks. As I already discussed, if routine checks are not there, there may be some inherent technical error, there may be some bias generation, etc. So routine check not only by the technical team but by the auditors, lawyers, etc. is also required. Otherwise, biased decisions may come. Otherwise, there may be data leak also. So all these things are to be taken care of. Now, another important thing is, which as I already discussed, but again it is a common mistake, that some organization are once deploying the AI and asking the technical team to do the technical updates, but there is no human oversight that how actually it is working. So for example, if it is done for retention, are employees actually getting the motivation, or if it is for learning, are employees actually getting the learning from the suit or the model which is instituted. So at each function level and for each of the product, human oversight is very important, and some organizations miss to do that. And sometimes when organizations are not following these dynamics and dimensions of explainability, transparency, risk assessment, and bias prevention, etc., then they may get not only into legal suits, but they may also end up getting losing a lot of financial aspects. So it is important that to maintain robust institution of AI, its good utilization, and for proper budget of AI, and also for mitigating any risks such as litigation, etc., proper care is taken. So these are the broad policy aspects. However, there may be some more dimensions which I think Arnav may want to discuss. So I would hand over to Arnav to highlight those.
Thanks, Renu. So, just to conclude now, because we have almost done with the presentation, some key takeaways. So, one important, just update to mention here, that in past we have seen, or in recent past, I will say, we have started seeing regulators started using a lot of social media inputs in relation to their own analysis of an organization. For example, recently there was one thing which has come out where income tax department was actually looking at the employee social media post to understand certain functionality of an organization. And in one of the case, they have also sent a notice saying that to that organization on from a tax perspective that as per your filings and as per your income tax returns, you are not doing conducting any business in India, but technically, quoting some employee post that this person in his LinkedIn profile has said that he has been working in a project in India for you. Now, whether that is going to be sustained in court, not going to sustain in court, it all depends on evidence, how they go after it and how they prove it. But what important here, and what we also have been understanding from some of our clients, one is HR tools AI. Second is when an employee is in an organization, whether how what kind of a AI tools they are going to use, and how the confidential information of an organization will be protected from that perspective. So that is again something, a kind of a debate going on, that like a social media policy, where as Tanvi said that that technically non-disparagement and all, but also means is organization is also need to have a policy on to tell which all AI products to be used by employees for their research and all, and what all information can be posted, because technically whatever goes in AI, AI uses it for its own learning as well. So 100% data protection and all those things cannot be ensured at to a largest extent of an AI. So that is something still to be pondered. So yeah, so just concluding on it, AI, we spoke and discussed of AI in hiring. We spoke about Workday matter. We spoke about Amazon case. We spoke about the other things where how the AI has been used. Similarly, Tanvi has spoken about the clauses, details of policy. Renu has spoken about policies, that now it's time to upgrade a policy, and very soon, see, Indian government is looking into AI from a various aspects. So one aspect is HR for sure, but then there are usage of AI for from a consumer perspective, how the interaction of consumer. So government is looking from various aspects, and if suppose there are audits and certification requirement comes in for usage of AI, it would also impact the usage of AI for HR functionality. So currently, lots of consultation papers has been issued by government. I would suggest that you all should go through Niti Aayog consultation paper, and if you are in fintech companies, then there is a white paper issued by RBI as well on this topic. So lots of discussions and deliberations are happening. It's time to go through that and be aware that there are certain policies which will require to be updated in your organization for sure. And at least for now, there has to be some placeholder because everyone is using some kind of AI to make sure that we are on the right side of the law, at least with disclaimers and policies. We are protected because we are using AI into our day-to-day functionality, into our day-to-day HR functionalities nowadays. So yeah, with this, I will rest the presentation part. Just to mention that LawKNIT, just to brief profile, we are a law firm based out of Bangalore, Mumbai, and Indore. Uh, we are full service law firm, provide from general corporate assistance to HR related, human employee related aspect to PE, VC, M&A, all kinds of practice areas. So from this, I hand it over to Gaurav. Gaurav, if there are questions, happy to take those questions now.
Yes, I can see. Yes, there's one question. If employees know AI is used in performance reviews, how can HR maintain their trust and confidence?
Great.
May I
Renu, would
address?
you like to answer? Yeah, yeah,
Yes.
please.
Okay, so this is very subjective scenario that when employees know that AI is used for performance review, so up to what level? However, it is very pertinent question also that how the confidence can be maintained that algorithm is checking what my performance is, whether it would be biased or not. So in those cases, explainability and transparency comes handy, that uniformity is maintained. So for example, if AI has say X number of parameters, it must be same for all the employees. So if that transparency is maintained, then confidence is instilled. But there is one exception. If performance appraisal or review is leading to termination, in those cases, at least as of now, under Indian law, AI cannot be deployed because there is concept of due process, and due process is to be followed. As far as AI is consistent with the due process, if it is only complementing and assisting the due process, then it is okay to have some AI tool assisting, but completely it cannot be left on AI. In courts also, that judgment criteria is there, no? So AI can only assist, it cannot be completely doing the whole work. So it may be complementary tool only. So likewise, when in organization some assessment is done or appraisal is done, which is either leading to promotion or leading to termination or retrenchment, in those cases, because there is some element of judgment and assessment, some element of decision making, so that decision cannot be made by AI tool. So as of now, that is the scenario. I hope it helps. And Dipali, is there anything?
Yes, that answers your question, Dipali. Anyone else? Has any doubt? If you can know, if you want to unmute yourself, guys, you can now raise your hand. I can unmute you. Or else if you're not comfortable speaking on mic, you can now ask question in a chat box.
So anyway, our details are with Gaurav and PocketHRMS team. And anything with regard to these things on documentation on AI, we are always accessible on our email IDs.
Yes, if you have any queries, if you want to ask, and if you have any personal questions or if you have any related question which you want to ask to Team LawKNIT, then you can contact us, or you can even visit their website and get in touch with them for your all legal things. Any other questions? There are 35 people, 34 people. All right, then I guess it's time to wrap today's session. It's already, we have reached 4:10. Yes, already
Yeah.
1 hour. We spent already 1 hour. So thank you guys for joining today's session. Okay. In this session, we saw like how AI is transforming the recruitment and the employee life cycle, and but also why fairness, transparency, and data protection must remain at the core. Okay. So AI should, what I think is AI should support the HR decision, not to replace them, right? And yes, we have to deal with this new advancement coming every day. We are coming, we can see if you open the LinkedIn, there's new AI tool, there's new enhancement is happening, and with respect to law as well, number of things will happen soon in Indian context. So thank you so much on behalf of PocketHRMS and Team LawKNIT. Thank you once again for being a part of this wonderful session. Thank you, Team LawKNIT, for this insightful session, and hope to see you soon.
Thanks everyone. Have a
Thank
nice
you.
weekend. Okay. Bye.
Bye bye.